lot, but I'd just like to thank everyone for tuning into our talk. This is a key topic for many Barbican residents to learn about lease extensions and the process the City of London use. I'll just talk briefly about Carter Lemon and Camerons. You can see on the screen there different types of work that we do: residential and commercial property, litigation and all forms of dispute resolution, including divorce, corporate and commercial transactions, employment and immigration, and wills and probate and tax planning. As many of you already know, we're a city firm based in King Street, opposite the Guildhall. So we're very convenient for Barbican residents to come and see us, and they're very welcome to come and see us. We've got a total staff of 37, I think, at the latest count, of which 22 are qualified lawyers working in our specialist departments. The firm was founded in 1915. Some of us worked at the firm for quite a long time, but no one's been here since the firm was founded. So we're all newcomers, really. We've been dealing with Barbican residents for many years and are familiar with the City of London lease extension process. I will now introduce you to my colleagues who are going to help me this evening. In fact, they're going to do most of the talking and I can relax. So just about me, first of all, while I'm up there. As Helen's already introduced me, I'm Ian West. I'm a partner in Carter Lemon and Camerons. I've been at Carter Lemon and Camerons since 2009. I deal with all types of property, but focusing quite a lot these days on residential property and certainly Barbican lease extensions. I've also got some experience of dealing with trusts, estates, and that background does help in some aspects of property transactions. So I'll let you introduce the others now. So we're going to swap seats to do this. So we'll see a little bit of musical chairs from us. It's probably a bit easier because our camera hasn't got very much wide panning on it, and we'll have to get a proper director of that studio or something next time.
Good evening, everyone. My name is Lease. I am a partner in the residential conveyancing department. I assist Lisa and Ian with the lease extensions, and I mainly deal with residential conveyancing, so deal with overseas buyers, UK residents in their residential purchases, and I'm going to be speaking to you later in the talk, and I'll hand over to Lisa Jesse.
My name is Lisa Genesi. Just to confuse you, you've got two Lisas here, but for those that are still awake, you see that we spell our names differently, which is very convenient. But I'm a partner here in our dispute resolution department. I specialise in resolving property disputes and serving formal notices. Although I regularly also advise on all sorts of dispute resolution matters and debt recovery, and I've been with the firm for about 30 odd years. Lisa, could you just move that up? In terms of what we're going to talk about tonight, we thought we would focus on what we consider to be the most commonly asked questions about lease extensions. So what we're going to talk about is what it is, why you should do it, what you should consider when you do it, how much it will cost, how you do it, and what can go wrong. Our talk's going to focus primarily on the Barbican lease extension process, which, courtesy of the City of London, is quite a streamlined, simplified process. Although, having said that, some of the general principles that we're going to talk about and mention tonight also apply to other leasehold properties outside the Barbican, so it's a general application. My part of the talk is going to focus on the law as it currently is, and Ian is going to touch on the new Act when that comes in on a date to be confirmed, and he'll talk about the changes as to what the Freehold and Leasehold Reform Act 2024 may bring about. So starting with the first question, which is what is a lease extension? A lease extension is a statutory right that all leasehold owners have under the Leasehold Reform Housing and Urban Developments Act 1993. And what this right gives you is if you have a long lease, as all the Barbican residents do, effectively over 21 years, you have a statutory right to ask or demand that your landlord gives you an extra 90 years to your lease in exchange for a premium and in exchange for which the ground rent under your lease gets waived or gets done away with. In terms of the car parking leases, we've been asked by a few Barbican lease residents who have leases of car parks whether they can extend those leases. Our current view is that they probably can't, although it's not a black and white case as to whether they are entitled under the Act to extend their leases. Nobody has yet done it that we're aware of, and I think certainly it's a very grey area as whether you can do that in any event. In relation to the question of why you would want to extend your lease, generally the longer your lease is, the more valuable it is. And all things being equal and subject to market trends, the likelihood is that the amount of money that you pay for your lease extension will be added to the value of your property and the value of your lease. So effectively, you'll get back, in all likelihood, the amount of the premium that you pay on the lease. So you are, in effect, investing in your own property, and by extending your lease, you're making it more marketable and more easy to mortgage. In relation to when is the best time to extend your lease, a bit of the new Act which has come in is that you can extend your lease immediately on your buying a leasehold flat at the Barbican. Previously, you had to wait until you had been registered 2 years. That has not now gone. You can immediately apply for a lease extension, and that in the past caused some confusion as to whether you wanted, when people wanted to sell their flats, often what they would do is they would start the process themselves, then sell the flat because the new buyer wouldn't have had the 2 years to qualify, and you would assign your right, the first tenant's right to the lease extension to your buyer. So that was what used to happen in the past to get round that. In terms of when is the best time to extend your lease, the best time under the current law to extend your lease is before your lease has got less than 80 years left to run. The reason for that is that once your lease drops below 80 years unexpired, the premium, how much you have to pay to get the lease extension, increases. And I'll talk about that in a bit more detail. In addition, at the moment, when leases go under the 80 years left to run, generally mortgage lenders get a bit nervous. And there are some mortgage lenders out there that are hesitant to mortgage leaseholds that have got less than 80 years left to run. So primarily the best time to do the lease extension is when you've got at least 80 years left to run. In relation to the Barbican leases generally, I know a lot of the leases that we have seen will expire at the end of June of this year in terms of 80 years. So on the 1st of July, there's going to be a lot of years that are, a lot of leases that are going to be 79 years and 364 days, which just tips you into this extra premium or extra cost for the premium bracket. So we're envisaging, and we've already seen it really, quite a rush of people that haven't yet, that have got their 80 years coming up in July, of doing that before then. So if it's something that you think you want to proceed with, you should really get on with it sooner rather than later, because as I said, it will get more expensive. So moving on to what the premium is going to look like. The Act, the 1993 Act, that is, sets out how the premium is calculated, and generally it's a matter for a valuer to advise on what the premium would be. And the premium takes into account the number of years left in your lease, the market value of the flat, and the loss of the ground rent to the freeholder. In terms of the marriage value, this is what kicks in if your lease dips down to below 80 years left to run. Under the current Act, if you have a lease which has got less than 80 years left to run, the value of your property, which is increased after you get the lease extension, is split 50-50 between yourself and the landlord. So, for example, say the value of your property is enhanced by 10,000 because of the lease extension. When you dip below 80 years, the marriage value kicks in, which means that the landlord is entitled to add to the premium 50%. So effectively, the premium would go up by 5,000 in that example that I've given. In terms of the valuations in the Barbican process, the City of London have a very streamlined process, and what they are prepared to accept is they will accept market valuations that are sent to them, and generally they accept most local agents. So we've seen lots from Frank Harris, Hamilton Brooks, Nicola Lee, and Scott City that provide valuations in terms of what the value of your flat is as it is, in terms of without this extension. That valuation then gets given to the City of London, who apply a formula, and that comes up with the premium. So generally, we start the process by taking the valuation from you and then liaising with the City of London for what the premium is. They're very exact in terms of the premium that they come back with. It's rounded up to a 3 or 4 pence, and they never, to our annoyance and the annoyance of our council department, they never round it into round figures. They've got a very set formula which they stick to. In all the years that we've been acting for Barbican leaseholders, nobody has ever challenged the formula or the premium that the City of London come out with. They are more than able to challenge it should they wish to do so. But to do that, they would need a full valuation report by an expert, which is probably going to cost a few £1,000s. And in addition, if the premium cannot be agreed between the landlord and tenant, effectively you have a remedy, a right under the Act to ask the tribunal to decide what the premium is. And again, the tribunal would consider the evidence of both parties' experts, valuers, and decide what the appropriate premium is. But we can say, bearing in mind that we do a lot of lease extensions for other flats outside of the Barbican, that generally our view is that the formula or the result of the premium that the City of London asks for is significantly either less or certainly very commercially competitive in terms of other premiums that other landlords have asked for. So they have such a streamlined process in terms of minimising costs and making a very fast process that helps them save costs as well. In terms of what the premium guide is, we are seeing normally at the moment is between 1.95% and 2% of the value of the flat. So if you come up with a valuation, as anybody that's good at quick maths, if you've got a property which is valued at 500,000, the premium is going to be 10,000. Similarly, if the valuation of the flat is £1 million, you're looking at a premium of £20,000. The next slide is really just to touch on how you do go about extending your lease. As I said, the first process we undertake in terms of if you instruct Cartland Camerons to do your lease extension is we will take your ID. I think Lisa's going to talk a bit more about how we do that and what documents we need, and we obtain your valuation. We then liaise with the City of London in terms of what the premium is, get confirmation on that, make sure that you're happy with that, and then we start the statutory process. The process is started by serving a rather formal Section 42 notice. It's got some standard wording in it, and it's got some dates and some figures that you've got to get right in there in terms of the dates for the counter notice, etc. And you do have the option at that time to flag or to mention in your Section 42 notice if there are any big amendments you want to have carried out to your lease. Now, there are statutory restrictions on what amendments are permitted. you can't, change everything around. The only amendments that will be allowed is general updating, and also in relation to whether there are any obvious errors in your current lease. I think we've only had this once where we've tried to correct an error, which the City of London were very helpful in, and they agreed to, and that was that I think a lease plan had been put, the wrong lease plan, or there was some line which was incorrect, and so we mentioned that, we flagged that in section 42 notice, and it was corrected. But as I said, generally, the section 42 notice is not going to talk about changing your lease in any substantial way. Once the section 42 notice is served, we then protect your right to the lease extension by registering what's called a unilateral notice against the City of London's freehold title, and that just makes sure that your right is protected. Strictly speaking, the landlord is entitled to request at this early stage a deposit of 10% of the proposed premium. The City of London have never, in our experience, asked for the 10% deposit, but certainly, for example, if you were looking at doing something like this for a flat which is not in the Barbican, most other landlords would be quick to ask for the 10% at this early stage. Once the section 42 notice has been served, the City of London is then required to serve a formal counter notice within 2 months. And they normally do so attaching the new lease for us to look at. And then the process starts of checking the lease. Although these documents are pretty standard, Section 42 notice and the counter notice, it's important to note that there are some teeth, if you like, in the 1993 Act, in that if you get some bits wrong, if you put the wrong dates in, or if you miss some of the deadlines, it can have quite serious consequences. One of the consequences, if you get it wrong, is firstly you invalidate your notice. A second consequence is if you get a date wrong in terms of periods of counter notices and making an application, there's what's called a deemed withdrawal of your section 42 notice, which kills the notice off, and you're not allowed to serve another notice under the Act as it currently is for a period of 12 months. So that has quite a sting in its tail. I'm going to now refer you to my colleague Lisa, who's going to talk about the sort of what we call the second stage of it. I do the first stage, which is serving the notices, and then I pass the file to either Lisa or Ian to deal with the actual agreeing of the lease. I'll just pass you to Lisa.
Hello. So I'm going to have a chat with you about what happens once Lisa has received the Section 45 notice and the terms have been agreed. The lease will be issued in two identical parts, a lease and a counterpart. The landlord will sign the lease and you as the leaseholder will sign the counterpart. To complete the lease, we have to provide the signed counterpart lease to the landlord, pay the balance of the premium, pay the landlord's costs, and our costs are also due on completion. In addition, the legal department at City will check with the service charge and ground rent departments that all payments are up to date. If they are not, then we will get a notification saying that we need for you to arrange to settle any arrears on your accounts before they will complete the lease extension. Okay, so once completion has taken place, the City will forward me the original lease, which I will then arrange to submit to Land Registry for registration. Many of you may be aware, if you've dealt with any conveyance in the last few years, that there is a significant backlog at the Land Registry. They have a backlog of up to around 12 months to deal with the registration of the extension. While we have seen some improvements in the times, we cannot predict with any certainty how long it will take for your lease extension to be registered. There are exceptions. If you are selling a property or if you are remortgaging, what you can do is you can provide us with a letter or a memorandum of sale from the estate agent or a copy of a mortgage offer from your broker or lender, which we can submit to the land registry. Once that has been submitted to land registry, with our request for an expedition of the application, they will usually pick that up within 10 days, 10 working days. That doesn't mean that your application will be completed within 10 working days. It just means that they will bump it up the list and pick it up within 10 days and start processing it as quickly as they can. Once the registration has taken place, we will of course let you have a copy of the updated title, and the original documents can either be retained in our storage, or we can send these to you, but you should retain the originals, as some buyers or lenders would like you to hold on to the original documents. However, if the originals are lost, you are able to obtain copies, certified copies of these from the land registry. So I will now move on to what we will do when you are instructing solicitors. We are required to check your identity. The requirements are that we carry out see a photo ID, usually your passport or your driving licence, and then 2 recent bank statement or utility bills showing your current residential address. Those documents are then, we ask you to follow a procedure using Verified 365, which verifies the validity of the documents. It also checks that the address is correct and that they have that the local authority and various other departments have you registered at that address. They also check whether or not you're a PEP or if subject to any sanctions, which of course we are required to check as part of our ID verification. We will also ask you to provide source of funds for how you will be funding the lease extension process. This usually requires us to have copies of your bank statements showing where the funds are held, and also an explanation for how those funds have accrued. For example, if they are a gift, if they are from your savings, or if they are from pensions or other, but we can address that in more detail to instruct us. In addition, we would need to see your existing lease and title. Obviously, if you don't have copies of these, we can obtain them from the land registry. Okay, so now we move on to how much it will cost. So in addition to the premium, you will need to pay for a market valuation. The city will usually accept market valuations from Frank Harris, and other local authority, local agents, and they will charge a nominal fee for that. You will need to check with them how much they charge, but this is usually a nominal amount of around £120. You will need to pay the City of London's legal fees. The City of London's legal fees are currently £635. In addition, you will have the solicitor's fees. So our charges are charged in stages. So for the first stage, which Lisa deals with, which is reviewing your title, preparing and serving the Section 42 notice, registering your notice on the title and checking their counter notice, there is a fee of £1,000 plus VAT. If there are changes to your existing lease, either recommended or that you have advised that you would like to take place, and we need to advise you further on those, we would charge an additional fee of not likely to exceed £500 plus VAT for reviewing that. That can deal with, as Lisa said, any defects in the existing lease. Secondly, the stage 2 will be reviewing the new form of lease, dealing with your signature to the same, obtaining funds, completing the lease and dealing with the registration at land registry. Again, there's a fee of £1,000 plus VAT. In the event that you needed to go to tribunal, that again would be dealt with on a separate fee, which would be discussed with you at the time. In addition, you would have disbursements, which around £150 in total, includes obtaining copies of the title documents from the land registry, the search fees, registration of the notice against the title, a registration of the lease extension, and registration, the bank admin fee. And I will now hand you over to Ian.
Very much. Thanks very much, Lisa. So I've got some headings now, miscellaneous matters. But are very miscellaneous, so I think they are relevant and perhaps answer some questions that people might have about the process. So the first thing I'm going to talk about is stamp duty land tax. Now, stamp duty land tax is payable by the person acquiring an interest in land. And the charge is based on the purchase price, in the case of lease extension, the premium which we pay to the City of London. The purchase of a lease extension is the purchase of interest in land. For most bargain lease extensions, I wouldn't expect there to be any stamp duty land tax payable. Where the lease extension relates to the purchase of a main residence, the stamp duty land tax is only payable if the purchase price is £125,000 or more. Where the lease extension relates to the purchase of a second property, the threshold is lower, it's £40,000, and higher rates of stamp duty land tax will be payable. Now, I've not yet seen a purchase price for bargain lease extension that exceeds £40,000. But if the premiums demanded are now nearer than 2% of the value of the property, a lease extension for a flat in one of the towers may be close to being chargeable to stamp duty land tax if it's a second home. Stamp duty land tax must be filed, stamp duty land tax return must be filed with HMRC if the purchase price exceeds £40,000, even if no tax is payable. So if we get to a point where the premium is above £40,000, but it's we're talking about extending the lease on the main residence, there won't be any stamp duty land tax to pay, but we will have to file a return, and we charge you for extra for that particular process. Existing and new mortgages. If your property is currently mortgaged, it's more likely than not that your mortgage terms require you to obtain your lender's consent before purchasing the lease extension. I wouldn't expect there to be any objection to the lease extension because it shouldn't adversely affect your lender's security and very likely enhance the value of the property. But you should check with your lender and see what their requirements are, and we can certainly write to your lender on your behalf to let them know what your proposals are. There are some lenders may say that you need to sign an additional document to confirm that the lender's mortgage will transfer from your existing lease to the extended lease. But such a document's not actually necessary because the mortgage will transfer automatically where the extended lease follows the statutory lease extension procedure. If you require a new mortgage for the purchase of your lease extension, you should apply to your lender before you start the formal process for requesting a new lease. We can quote for our fees for assisting with the mortgage. We're on the panel of most mortgage lenders, but what our fee will be will depend upon the size of the loan. There could be additional disbursements payable, which your lender may require, certain searches that are usually carried out. It's possible, though, that lenders will, in those circumstances, accept a form of insurance in place of carrying out the usual searches, and that would be advantageous because it's much quicker than obtaining the search results and probably cheaper as well. Third item on the list there is about joint ownership and trust. Where a lease extension is being purchased by more than one person, we need instructions as to how that property is to be held. There are two types of joint ownership. They have a confusing name. One is called joint tenants and the other is tenants in common. They have nothing at all to do with tenancies. Joint tenancy is perhaps the simplest, where co-owners purchase the property as joint tenants. On the death of one of the co-owners, the deceased share passes automatically to the survivor. And in terms of the process of the land registry, all that's required is to produce the death certificate of the deceased co-owner, and their name will be removed from the title, leaving the survivor there. Where the property is held as tenants in common, on the death of one of the co-owners, the deceased share does not necessarily pass to the survivor. It will pass under the terms of the deceased's will, or where no will has been made, then under the rules of intestacy. When you have tenants in common, as of your choice, we'll need instructions on the proportions in which the parties will hold the property. Certainly with the proportions are not 50-50, it's maybe a good idea to have a trustee to set out what the proportions are. The other thing that a trustee can do for you is to set out in it an agreement between the co-owners on various matters. It might be on the circumstances when either party can dispose of their separate share in the property. It could impose limits on who can occupy the property. It could include details about who pays the outgoings for the property. If there's a mortgage, how the mortgage repayments are made. We obviously help clients if they need a trust deed, but we need to take specific instructions about what the clients want, because these are, once again, tailor-made documents, and some of them can be quite complicated, others can be fairly straightforward and simple to provide. One thing that would also be a good idea to consider once you've purchased your lease extension, or indeed at any time, is making a will. If you've just purchased your new lease extension, you may have increased the value of your property. That may be relevant to what you need in your estate. And our private client department will be able to help anyone who would like to make a will. If you've already got a will, it may be that it needs looking at and updating. I know that you should really regularly check whether your will needs updating. There may be specific things that happen in your life that make it fairly obvious you need to look at your will, but it's a good idea to perhaps look at it every 2 or 3 years anyway. So the last of my items, if I can work the system, yes, is talking about the Freehold and Leasehold Reform Act 2024. So this Act amended several existing provisions concerning the rights of leaseholders. And insofar as the new legislation affects lease extensions, although the Act received its royal assent back on the 24th of May 2024, not all of its provisions are currently in force. And there's no fixed full implementation date yet, but industry commentary suggests late in 2026 or 2027, or maybe beyond that date, for a realistic rollout of the Act's valuation and other complex measures. One thing that we can say is that the new Act will allow tenants to have an extended lease of 990 years rather than just adding 90 years to the current lease term. The Act also envisages being more streamlined in the process. Allegedly will be cheaper and easier to follow, but we've not seen all the regulations that will go with the Act when it comes into force, and certainly we haven't seen the new standard method of calculating the purchase price for a lease extension. We know that this new method will abolish the sharing of the marriage value that Lisa talked about earlier, where the lease has got less than 80 years to run. But we don't know when these new rules will actually apply, or the regulations that will go with them that set out the new valuation process. So the view of several commentators is that pending the publication of the new valuation regulations, tenants who have leases with 80 to 82 years left to run will be better off applying for a lease extension now rather than waiting to see what the new regulations will say when they're published. And we would go along with that view that it's better to make your lease extension application now, and given the fact that most Barbican leases will get less than 80 years after 30th of June this year, there's really only a few months to act if you want to go ahead with a lease extension. In practice, I think that if we receive any instructions, probably beyond the end of May, maybe middle of May, that may be cutting it fine to make sure that we get your application in for a lease extension before the end of June this year. But you know, the sooner you start, I think the safer you be, more likely will be that you'll get your lease extension in under the current regulations. So thank you very much indeed for listening to what we've had to say to you this evening. I'm sure some of you will have questions and we'll be very pleased to deal with them. So I think if Helen can switch on the right buttons for us to hear people who have got questions, then we'd be very pleased to hear them, and I hope they can still hear us.
No, well, thank you, Ian, for another great session, and may see you at the next one. May you'll be too busy processing all of these, I expect.
Well, thank you for organising this, Helen. Thank you for those people who have attended today. Obviously, if we've gone through a session this evening. There's quite a bit of information really to absorb. And it's all second edge to us, but appreciate it for most of you. This is very novel. So if you have any further questions, you can email me or either Lisa, and we will get back to you and hopefully answer your questions to your satisfaction.